Welcome back to the page, everyone. This video will be discussing signatories to Articles of Association. Now, under the Companies Act 61 of 1973, the old act, every company had to register its Memorandum of Association and its Articles of Association, while the previous acts imposed various requirements on the form and content of the memorandum. It did not govern the content of articles. In terms of the 1973 Act, it was legal to alter the memorandum and the articles independently of another through a shareholders' special resolution. Additionally, the memorandum and articles were binding between the members, shareholders of the company, and the company itself. Now, however, the rules have changed quite drastically under the Companies Act 71 of 2008, the new act. The Memorandum of Incorporation is a legally binding document between shareholders themselves, between the company and shareholders, and between the company and third parties. Now, existing companies that registered under the old act must align the existing articles and memorandum with the provisions of the new act. The legal nature of the Memorandum of Incorporation is that, or a Memorandum of Incorporation is also defined in the new act as an instrument that sets out rights and duties and responsibilities of shareholders, directors, and others within and in relation to the company, and other matters are contemplated in section 15, and by which, firstly, the company was incorporated in terms of this act as contemplated in section 13. Secondly, a pre-existing company was structured and governed before the later of the effective date or the date it was converted to a company in terms of the schedule. Secondly, according to the Memorandum of Incorporation, now combines the Articles of Association and the Memorandum of Association in one legal document and broadens its purpose. Currently, the Articles and Memorandum of companies registered before the new act was introduced will automatically form its Memorandum of Incorporation. However, these companies should ensure that their existing articles and memorandum conforms to the provisions of the new act. The act requires all companies to convert their existing memorandum and articles of association to a Memorandum of Incorporation. Now, the continuation of pre-existing companies. Schedule 5, Item 2 of the Act, Item 2, Sub-Item 1, every pre-existing company incorporated under the previous Act or recognized as an existing company will continue as if incorporated and registered under the new Act, with the existing name and registration number subject to Item 4 of Schedule 5. Now, the Memorandum of Incorporation rules and shareholders' agreements of pre-existing companies is governed by Schedule 5, Item 4 of the Act, which states that a pre-existing company may file within 2 years of the general effective date of the new Act, without charge, an amendment to the Memorandum of Incorporation to harmonize it with the Act, and if necessary, a notice of name change and copy of a special resolution under Section 16 to alter its name to meet the requirements of the Act. The following companies will be deemed to have amended their Memorandum of Incorporations from the general effective date of the new Act and to have changed their names insofar as required to comply with Section 11, Subsection 3 as follows. A Section 21 company to expressly state that it is a non-profit company. A Section 53 Paragraph B company to expressly state that it is a personal liability company incorporated. A company failing within the definition of a state-owned company in terms of the new Act to have changed its name. A company limited by guarantee other than a Section 21 company may file a notice within 20 business days after the general effective date electing to become a profit company. If not, it is deemed to have amended its Memorandum of Incorporation from its effective date or from the effective date to expressly state that it is a non-profit company and to change its name accordingly. Lodgement of the Memorandum of Incorporation post the 2-year period will attract a prescribed fee. Now, electronic signatures, communication and substantial compliance. Section 6, subsection 10. If in terms of the Act, a notice is required or permitted to be given or published to any person. It is sufficient if the notice is transmitted electronically directly to that person in a manner and form that the notice can be conveniently printed by the recipient within a reasonable time and at a reasonable cost. Now, a notice of meeting to shareholders as contemplated in section 62 may be in writing or electronic form unless the company's memorandum of incorporation provides otherwise. Faxes, telephone communications, and conference calls are all electronic communications which are suitable for establishing a virtual presence for purposes of meetings as contemplated in the Act. Now, section 63 relates to shareholders or shareholders meetings, and section 73 refers to board meetings of directors and provides that a meeting of shareholders and directors respectively may be conducted entirely by electronic communication, or if held in person, one or more of the shareholders, directors, or proxies may participate by electronic communication, provided that the methods employed enables all persons participating to simultaneously communicate with one another or with each other without an intermediary, and to participate reasonably effectively in that meeting, and so long as the memorandum of incorporation allows for it. In such a case, the notice of that meeting must inform the shareholders, directors, whichever is applicable, of the availability of that form of participation, and provide any necessary information to enable shareholders or their proxies, directors, to access the available medium or means of electronic communication. Such access is at the expense of the shareholder or proxy or director, except to the extent that the company determines otherwise. Thus, the definition of present at a meeting includes a virtual presence or representation by electronic proxy. If you guys want to know more about this topic or read about it, it is on our website www.𝗪𝗲𝗀𝗋𝗲. Please do give our video a thumbs up. Also, like and subscribe to our YouTube channel, and stay tuned for more videos like this.